on record at 3:18, and we're going to pick up with the last few questions of section 3.
So picking up with 31.
31.
What are the board's legal requirements regarding the approval of international schools? And so we just reference back to our Business Professions Code 2651, and then also the accreditation by CAPTI and Peace, and anything outside of that would have to follow. And we have not approved any schools, the board itself, anything outside of the CAPTI or Peace accreditation. Continuing competency, continuing education / competency requirements. Again, this template was written for more than just the Physical Therapy Board of California, so continuing education, continuing competency could be considered to be synonymous. Describe the board's continuing education competency requirements, if any. And so we just provide regulatory citations and a basic description of 30 hours per 2 years, with 2 prerequisites of 2 hours in ethics, laws, and regulations, and 4 hours in basic life support for healthcare providers. How does the board verify CE or other competency requirements? And we provide an explanation that essentially describes the recognized approval agency process, as well as creation of content or providers themselves to be accredited by a recognized approval agency. One of the questions above does ask about using DCA's cloud services. And currently we don't use the cloud services for anything continuing competency related. We have recently started using the cloud service for some enforcement processes, but we'll explore looking at the idea of using the cloud for CC at a later date. Does the board conduct CC audits of licensees? And of course, the answer is yes. And we provide a description of how that process works. What are the consequences for failing a CC audit? Which ventures from anything from a warning letter to a citation.
So I know that the question doesn't ask it, but might we want to consider including that licensees are given the opportunity to come into compliance, or is that not necessary here?
We do touch on it above in
Okay.
question B.
Okay.
If a licensee demonstrates sufficient compliance with the continuing competency requirement, the licensee passes the audit. Essentially what that comes down to is looking for compliance of the spirit of the statute. We know just from our own experiences that there's a lot of content out there for physical therapists that will benefit them in their profession, but that aren't necessarily accredited for the state of California. Mm-hmm. And because of that confusion, we don't want to punish the licensees for those. We want to encourage them to continue to expand their knowledge base. So if we run across that in an audit process, we'll explore a couple different options. One of them may be, getting that particular provider to seek accreditation, doing a retroactive approval, having the actual applicant or the licensee that's being audited seek accreditation for that content. And then just also applying discretion where it's we know that the content is so clearly physical therapy services or patient-client relationship services that we'll just give them a waiver or an exception to the rule.
Nice.
Here's one of those situations where the raw numbers really can't help. How many CC audits were conducted in the past 4 fiscal years? And in the past 4 fiscal years, we conducted 1,462 audits. Keeping in mind that there's a good portion of this particular sunset period that was, continuing competency audits were put on hold as a result of the global pandemic and the waiver of continuing competency requirements, so that number would naturally be higher without that. We don't have a very significant failure rate. Examples of those failures could be somebody who just refuses to participate in the process altogether, or who refuses to come into compliance once a deficiency has been identified. And then we do speak to the waiver that the director provided for continuing education. But honestly, with 1,462 audits, even if we had done that over the 4-year period, I think that's quite a bit compared to some of the other numbers that I've seen.
Good. Is it? Good. Good job.
Similar to previous discussions that we had, of these 90 that failed initially, the audit, how many of them came into compliance?
All of them came into compliance as a result. It's part of the citation process.
Is that stated here, or did I miss it?
I don't think that we've explicitly stated that.
So I think there were 90 licensees initially deemed insufficient / failed their audit, but all came into compliance. And licenses were not reestablished.
Renewed.
Renewed. I mean, that just helps to go to your story about they're given the opportunity to get it fixed, and that nobody ended up suffering, losing their license.
So I think I'm going to add a little, with the help of staff, I think I'm going to add a little language to C and to D. Right, so when we talk about what are the consequences, I'll actually kind of describe what the range has been over the period of time.
And instead of starting off D with, for the past 4 years, I would maybe say between 2016 and 2019, prior to pandemic. Or the dates prior to pandemic, not necessarily saying prior to pandemic. We conducted 1,462. Since
I see what you're saying.
onset of pandemic, no further audits have been conducted at this, because of circumstances. That way, that to me helps focus. No, you did a lot during those. A lot of audits were performed. You were really looking,
That's a good
It's
point.
softer the way it is now, that it takes more thought, but I think putting that up front helps to really address the question, get them to be
Okay.
clear.
And those two are going to take a little crafting, so we'll bring those back tomorrow. Anything else for C or D?
None.
So for E, the CC course approval policy, remember that this template was written for all of the department. And some boards are in the business of accrediting actual content. And so we just give a description of, again, the recognized approval agency, and cite the regulatory authority for that.
The very middle of that paragraph, the word much, I think should be must.
Thank you. On to F, who approves CC providers, who approves CC courses. If the board approves them, what is the board's application review process? Again, we talk about just the recognized approval agency and the regulation that was stated above. Question G has a little bit new content into it because of the time duration since the last sunset. while we do not directly approve courses or providers, we do maintain data provided by the recognized approval agencies, and as of November 21, there are 131 recognized approval agencies, 298 providers, and 14,327 courses. And all of that is what we know of, right? Again, that doesn't speak to those content providers or courses that might be offered in other states that haven't gone about the accreditation process in California. This is just the ones that we know are already accredited in California. We received 7 new applications, and while we've only done 7, we have had a lot of interest in people inquiring to become a new provider or a new recognized agency. I think we should correct provider to recognized approval agency. Does the board audit CE providers? Again, a little bit of the explanation for recognized approval agencies, but as part of the audit of recognized approval agencies, we are looking at content and providers themselves, and that they adhere to the regulations. And most importantly, that the recognized approval agency holds them to those standards as well. And just a brief description of what that process would look like. Describe the board's effort, if any, to review its CE policy for the purpose of moving towards performance-based assessments of the licensee's continuing competence. While we've assessed the CE policy for a lot of different reasons, we have not assessed it for that purpose. So the answer is we have not reviewed it, our policy for the purpose of moving towards performance-based assessment of licensees' continuing competency. We were a little torn on this question because our statute actually prohibits us from doing that. And so I didn't go so far as to point that out. I just said we didn't explore it.
Okay. Do you think the table should be moved up toward the top of the list of questions?
I think it's a preference call. I think if you think that it helps, we certainly could do it. It's not a problem at all.
I mean, these are all addressed at the very beginning of this whole section.
It's mundane enough. I think it adds to the conversation. It adds to the reader's understanding. It might help them kind of take in the answers to the questions a little bit better. Move it to the front.
What do other members think? Or staff? I mean, the first couple of questions asked about describing the number of hours, and then the second or third question asks about audits, so. You can try it,
So under 32, but right before A. Okay,
yeah.
we'll make that note. Anything else regarding CC before we move on to enforcement?
None for me.
Okay, so we'll pick up with enforcement program, question number 33. There is some content here, some historical content here that is outside of the range of the Sunset Report, but I think it's important to the conversation because the performance measures themselves are a result of the Consumer Protection Enforcement Initiative, the whole reason for their existence. So some of the language that we used in the last sunset, we've used here with a little refresh, but it describes the history, how we got here, talking about the 12 to 18 months, all the way back in July of 2010, and the licensing enforcement, or the CPI, the Consumer Protection Enforcement Initiative. As a result of that initiative, we have the performance measures as we know them today, and also rightly states we're currently meeting our performance targets with the exception of performance measure PM3, cycle time for cases not resulting in formal discipline, and cycle time, or PM4, cycle time for cases resulting in formal discipline. We go through each performance measure. We provide kind of a simple or a basic definition for people to understand what that performance measure actually measures. Starting with complaints received, going into intake, and as you can see in intake, we've met our measures by a pretty easy margin. One thing just to remind the members to keep in mind is that the numbers that were determined back in 2010 were somewhat arbitrary. They were kind of, would like to have targets. And so while we typically do it in 3 to 4 days and the target of days is 10, 10 might have been an overshot. We might have, been better stating something like 7 days or something like that. But as long as we're under it and we're meeting that performance, so be it.
Yeah, this section, I think it's really easy to read. It's good.
Moving to performance measure 3, intake and investigation. These are a little bit different. The only kind of recommendation I would make to the chart is being consistent with, well, it is consistent, it's fine. The average days being in front of the target, I think sometimes had me dancing around the pages a little bit, but we are outside the target number of days, but not by much, right? And so Elsa has gone down, taken those numbers and broke them down in the bullets below. And so what we can see is of the number of cases, 270 cases were closed within 90 days. 426 were closed within 1 year. 24 were closed within 1 to 2 years. 6 cases were closed within 2 to 3. 2 cases were closed within 3 to 4, and we didn't have any cases that spanned past the 4-year mark. And this is that statistic where we were talking about those cases can skew your averages and don't really tell the story that the legislature is looking for. And so you can see only about 10 cases were problematic and didn't meet the measure.
So right at the bottom there on the screen, down a little more, we have the comment. I wonder if that's it. Maybe down more, I'm sorry, under this, yes. So we have the comment, PM3 target was not met, however. And then in the very next sentence, it says the same thing. Although the PM3 target was not met in over 56, it's a redundant sentence. What's the comment describing?
1 second.
Carol's going to tell us all about it.
So each of these tables references just one fiscal year, and then the breakdown of cases per,
I see it.
cases closed per 90 days or 1 year or 1 to 2 years. And so the comment, while it looks repeated, it's for each separate fiscal year.
So we'll have to change the title of each table to incorporate it's there in the bar below above quarters, but if we put it in the title, it might make it easier to discern.
Make more sense that way.
Well, or we just make sure the table lands on a page and doesn't get split. Because if it's not split, it's a little bit easier to understand.
Yeah.
Just make a note of that real quick. And then, so the comment below each of those refers to that particular measure.
That table.
Right.
The table directly above it.
Okay.
Go back to 1819. I'm wondering if there's a wrong number under one of these. Should the cases within 1 year underneath, should that be 426? It just jumps out at me that that's,
Yeah, I have the same question, and I think if you looked at those 426, because of the average days in the table, they're probably closer to 90 days than they are to 1 year. So, yeah, it looks like it skews you out.
okay.
But
So, yeah,
it's probably
there's-
like 95 days or 107.
I just wanted to make sure it was the right number.
So, yeah, that's a good point. Should we, I don't know, just for the way that the scale is, it's 90 days and then it jumps to a year, 1 to 2, 2 to 3.
But yet that number is
Yeah.
really inflated compared to the other years.
Because of the time frame that was chosen.
I could just go back to the data and confirm that 426 is correct.
Thanks,
And
Carol.
does that 426 include the 270 that were,
It does not. Each number is separate.
there were that many cases?
I'll confirm for sure, but yeah,
Yeah.
that was the intent, that
Okay.
outside of the 270 that were closed within 90, an additional 426 were closed within a year.
But as Jesus points out, they could have been 91 days or 93
Correct.
days.
Anywhere from 91 days to 365, yeah.
But if it is 476, that means that there were a lot more cases that year, too, compared to the other years.
Yeah, like,
I mean, it's almost twice as many.
yeah, 2 to 3 times as many.
We've seen a significant
Is-
reduction
Yeah.
in
Is-
complaints over the last 3 fiscal years.
Yeah, so you can come back and tell us, Carol.
Will do.
That's what it is.
I'm scanning, I'm trying to find a statement too that addresses I mean, I know it does say when formal discipline is involved, that cases take much longer, but it doesn't really, I mean, that to me, doesn't spell out that this is stuff that's with the AG, that it's out of our control. So that these cases that go on for very long periods of time are things that are out of the control of the board itself, of what we can do. And we have no way to shorten that time or to address that time, because it's in somebody else's hands for that long of a period. We need to, somehow that needs to be stated outright.
I think above, in the narrative, under CPEI performance measures, the last paragraph where it says we didn't meet PM3 and PM4, maybe that's where that belongs.
I mean, because where it's intake, like, we're,
Yeah.
you know, we're dynamite. We do exactly what we're supposed to do. We're meeting measures, standards that were set a long time ago. And that probably needs to be addressed now with the modern age. But, yeah, it's something, there needs to be something to continue, because we've discussed this many times about why our numbers reflect what they are with these really long processing times.
Yeah.
We know, but, yeah, to make sure that it's clear for a legislator to read it and understand it.
In the
So if you go
public.
down past all of
Yeah,
these
it's down there.
paragraph addressing that, I don't know if that's the right place for it, though.
Let's see.
Yeah, under comment, the very last paragraph before PM4.
So on page
Before PM4?
59,
Correct. It's on my page 60.
page 60, yeah.
Right here, PM3.
Ah. Is there a similar one for PM4?
And it's the little passage literally right above performance measure 4.
Yeah.
Criminal discipline.
And I saw that, but to me, it doesn't, it doesn't spell it out. Like, it needs, to me, it needs to say, these are cases that have transitioned onto, or are in DOI and AG, under DOI and AG control. Or something to that effect, that spells out where this delay is happening, where we're seeing this delay.
So PM3 is the ones that did not go to the AG, but they are with DFI.
Okay,
Yes, so that's external.
yeah.
The joint committee is really, they're aware of this, right? Yeah, Michael?
Well, they do see. I mean, they do see all of the boards, sunsets, and I think they're generally aware of the process and that the Attorney General portion tends to take up a lot of time in terms of prosecution.
So,
I'm not saying you shouldn't include a comment like this, but
right. So there is something there under PM3 and PM4. Dr. Drummer, do you want, would something under CPEI performance measures at the top in the narrative, in that very last paragraph, would something there help you, or would you want
Yeah.
something spelled out a little bit more in each P?
No, I think a little bit more general statement near the beginning, yeah,
Okay,
to me is the better place, because it sets the framework for everything below. And you can say, when matters are within PTBC's control, target dates are met.
We do touch on that in the narrative a little bit farther down, but I'll also tell you, just kind of watching this section of the report over the last couple legislative sessions, the committee's familiar, right? They understand the bottleneck situations for the boards when it comes to D of I and with DOJ, and more recently, even with the Office of Administrative Hearings. So I would just caution against emphasizing that point too much, because it's a little bit of, I think that doth protest too much almost, and I think our numbers are, for the most part, favorable anyway.
Okay.
So are we good with 3 now at this point?
3 and 4.
3 and 4? Okay.
I mean, they're both as
Yeah,
similar,
they're
right?
very similar. And then just to point out, you know, the tables themselves is the only thing that was asked for in the template. Every time they ask a table, we turn around and we do that kind of bullet out to kind of explain the statistical anomalies inside of that, just to tell a better, so that the reader understands a little bit more. I believe the tables lack quality, quite frankly. I mean, they ask the question, but they don't really get down to the rhyme or reason of why things are the way they are.
Right.
One of the other, I think, things that sometimes gets lost in the equation is understanding that cases can span multiple fiscal years. So while they may have concluded in fiscal year 2021, they were considered pending fiscal year 18-19, fiscal year 19-20, that kind of thing. And so it's a difficult process to understand. And that's why I think sometimes it's better to talk about a specific case, so you can look at that case if it's an outlier, if it's one of those 3 to 4 year cases. Performance measure number 7, probation intake. Again, this is a performance measure that was based on 10 days, semi-arbitrarily. But the board's probation monitor typically does that within about 4 to 5 days. There are times where the probationer can be sometimes hard to get in contact with. And so sometimes that does skew the number out. And we've seen that COVID might have a contributing factor to that with the most recent numbers, as well as our availability and how we are teleworking from home and that kind of thing. Performance measure 8. Again, we don't have these happen very often, but when they do, you can see the statistics from one day to the next. Once we're identified of a violation, we tend to take care of it pretty quickly. Question 34, explaining trends in enforcement data and the board's efforts to address any increase in volume or timeframes. Elsa did a pretty good job in narrative describing while we have a decrease in the number of complaints each year, and even more so in this last fiscal year, there's only reason to speculate that it was due to COVID-19. Some of that may be attributed to things like closure of facilities or layoffs or those kind of things, and patients not being able to receive physical therapy services because they weren't considered essential. One of the benefits of that is now with fewer cases and enforcement staff catching up on those cases, the number of cases per analyst has dropped, which makes, I think, a more manageable caseload, which ends up in a better quality product also. And then you can see fiscal year 18-19 with 555 complaints received, and then this last fiscal year down to 408. Again, I think in speculation, it's reasonable to think that has a lot to do with the global pandemic. And so we can certainly expect maybe those numbers to climb once we get into a state of normalcy. Performance barriers, we do describe some of the issues or problems that occurred over the last 2 fiscal years as a result of the global pandemic at times, but just some general issues regarding communication between our board and the Division of Investigation, our ability to obtain documentation from licensees and from local jurisdictions. Also explains that we are continuously reviewing and evaluating our workload and internal procedures of improvement. COVID has been a benefit in a way that some of the things that we would have liked to have done in the last few years, but there was resistance to do, either through lack of IT or just fear of change, if you will, are now becoming normal. We do transmit documents to the DFI through an electronic portal, as well as to the Department of Justice, and I don't know that those things would have been done if it had not been for the pandemic. Mm-hmm. And again, like earlier, we mentioned that we're also looking at DCA's cloud portal to assist us in electronic communication between the board's expert consultants as well, so that we can cut out some of those time delays, but also costs and mailing and that kind of thing. Table 9A reflects enforcement specifics very similar to the ones that you see above, kind of breaking them down a little bit. And as you'll see across the board, there's this spiral trend.
And this was a template table, this one here?
It is.
Yeah, it's pretty clean.
There's really not much of note in those tables, with the exception of maybe like citation and fine. And you'll see even there that this particular last year, there was a lot fewer citations, resulting in a lot fewer fine collected. But even in our disciplinary outcomes, we see a reduction in revocations and surrenders. Any questions in those tables at all? Anything jump out?
None from me.
Question 10 is addresses a specific current concern of the legislature about aging cases, and you can see that similar to the data that Elsa provided above in the performance measures, this kind of, you can look at that statistical skewing of cases, greater than 1 to 2 years, greater than 2 to 3, or over 3 years, and the numbers are very small considering how many complaints we're reporting.
Yeah.
35, the answer to 35 are very similar to some of the questions that we've been talking about above. It's reasonable to speculate that COVID has had an impact on our numbers. The number of accusations filed has remained relatively steady, correlating with the rise and fall of the number of complaints received. On to 36. Our case is prioritized. The PTBC continues to prioritize its cases in accordance with DCA's compliant prioritization guidelines for healthcare agencies that was created prior to CPEI. 3 levels of prioritization: urgent, high, and routine. We use those on a daily basis. Sometimes when we see cases that are on the edge of being routine and high, we will still defer them to DFI and ask them to look into them regardless of their priority matrix, but based on analyst or a concern by either the assistant executive officer or the executive officer. And then the last sentence of that particular paragraph says the priority of the case can be changed at any time during the investigation if warranted. And we have had cases that we thought were routine, but based after an investigation, we realized there was a lot more going on than we had originally anticipated. 37?
Yes.
Okay. Are there mandatory reporting requirements, for example, requiring local officials or organizations or other professionals to report violations? We have a few mandatory reporting requirements. Elsa has listed them out here in the BPC codes specific to the requirement. Some of those have to do with 800 codes as they pertain to malpractice lawsuits or discipline conducted by hospitals or facilities. Some of them are specific to the licensees themselves and having to report to us. And then we also have, also brings in the Federation of State Boards of Physical Therapy's ELDD, where we receive disciplinary information from other states that are participating in that database. There is a question, are there problems with the board receiving the required reports, and if so, what could be done? And Elsa does speak to that. There are several mandatory reporting requirements that are designed to inform the board of possible violations, but there's no way or means for us to verify that 100% of the reports are received. We don't know what we don't know.
So what can be done?
I think one of the things that you're seeing right now is they're talking about strengthening some of the 800 codes for hospitals. So there is for hospitals and clinics to report discipline. So there is some proposed legislation, but it's just something that we'll have to wait and watch how that process plays out.
But we're not offering any answer to that question, should we?
When we've been invited into the conversation, we provided feedback, but DCA has done that mostly on our part.
But I mean, the question asks, if so, what could be done to correct the problems?
Oh.
What's asking us, what could be done. Like we're saying we have difficulty getting the records, the documents, and they're important. Well, what are our ideas to rectify that, if any? Do we have any ideas? Or, Michael, you have an idea?
Well, I was just going to say that I don't really know that there's a solution to that problem that the board or any board could take. Because what you're talking about are malpractice lawsuits that aren't being reported. And in terms of your executive officer's comment, there's no way to know about them. That's the report is the means for the board to be informed of them, but there's no database, there's no way to verify that each one has been, because we're talking about lawsuits in, potentially 58 different superior courts in the state, federal courts, courts from all over the country. It's just there's really not a way to tie apples to apples in terms of have we received every report that we should have.
So I guess I'm thinking we should at least address the question, because they're asking. So if we have nothing to offer, I don't know. I mean,
I agree with what you're saying. I think there's some thin ice to walk on, if you will. And that's kind of why I alluded to that there is has been proposed legislation over the last 2 sessions about strengthening some of these authorities. It could be argued that the authority is already there. It's just not being enforced properly, right? So specifically to like hospitals and clinics who failed to report to their regulating agencies actions they took against their licensees, there's really not much that can be done because there's no regulatory body enforcing that particular part of the code. And the only person that I can punish is a license holder, right? And so the clinic not reporting discipline to us in a timely fashion, while it's a problem, is not something I can solve, given our authority. One of the other concerns, and again, thin ice as well, is requesting documents from local arresting agencies like sheriff's offices, police departments, and county clerks. And maybe through lack of education or what have you, not understanding that we're another administrative law enforcement agency and they can share those documents with us, either outright refusing to give them to us, charge us for them, or make us go through a lot of additional hoops to get them. How you go about strengthening the statutes that already exist there is more about those particular entities' understanding or legal interpretation of those statutes than anything else.
so it's almost better just to leave it as is than to say we don't have any suggestions.
I think so.
Okay, thank you.
I think that I would take the opportunity in conversation with a staffer, to bring up some of my concerns about those kind of things. We've done so in the past.
Thank you.
What is the dollar threshold for settlement reports received by the board? And currently that threshold is set at $3,000. Not too long ago it was $5,000, so it's not recently. Within the last 4 or 5 years it's been lowered. What is the average dollar amount of settlements reported to us? And you'll see through the fiscal years that it's fluctuated. And again, it's case specific, and so there's really no way for us to determine any kind of trend. And one, we don't receive them very often. Out of the 555 some odd complaints, malpractice suits are usually a handful. There's not many there, not enough at least to make any kind of determination from. Describe settlements the board and Office of the Attorney General on behalf of the board enter into with licensees. This is just an explanation of our settlement authority and some of the things that we go through in enforcement on a daily basis, explaining the range of our authority from public letter of reprimand all the way through revocation, And while settlement is initiated by the Attorney General, board staff and the executive officer work closely with that particular Attorney General on the terms and conditions to make sure that the model guidelines for discipline are adhered to the best that we can. What is the number of cases pre-accusation that the board settled for the past 4 years compared to the number that resulted in a hearing? The PTBC does not settle cases prior to the filing of a formal accusation. In lieu of filing or prosecuting a formal accusation against the licensee, the executive officer does have the delegated authority to issue a public letter of reprimand after we have conducted an investigation. That delegation to the EO without the board member involvement provides for better use of resources for those cases that do not warrant full discipline, such as probation. We use PLRs for minor violations that warrant a higher level of action than a citation might provide, but not necessarily probation. The PLR under its authority does not require the transmittal to the Office of the Attorney General since it's an agreement between the licensee and the EO. It is discipline and it is publicly posted. But if the licensee does not agree to the PLR will then be issued, will not be issued, but then an accusation will be filed and we will go through the traditional path. What is the number of cases post-accusation that the board settled for the past 4 years? And as you can see, we go through settlement much more than we go through hearing. And again, 18-19 was that kind of peak year of high numbers before we went into a pandemic, and we've seen a downturn since. What is the overall percentage of cases for the past 4 years that have been settled rather than resulted in a hearing? And we're at about 87%. Does the board operate with a statute of limitations? No, we don't. Dissimilar to some of the other healthcare boards, we are not hindered by any kind of statute of limitations. Describe the board's efforts to address unlicensed activity and underground economy, and I would just, remind the board that this template is designed for all of the department, and there are some professions that do suffer from a lot of underground activity. Physical therapy has not historically been one of those. And so we do provide an explanation of some of the things that we've put in place to stop that from happening.
I like it. It's good.
In those instances where we actually can find fault or unlicensed activity, because that particular person is not licensed, the only authority that we have is to issue a citation and fine a $5,000 fine per instance. And again, it doesn't happen very often.
I was wondering, I know they're not asking for it and we don't have to offer it, but do they want a sense of how often it happens or not necessarily?
I think not necessarily, because they're really trying to get to underground practice.
Yeah.
And when we're looking at unlicensed activity, sometimes it could be something as simple as an expiration of a license or another licensee infringing on the PT Practice Act, or a physical therapist who may aid and abet a PTA in the unlicensed practice of physical therapy. So it's for a different purpose.
Okay, thank you.
Question 41 in cite and fine. Discuss the extent in which the board has used its cite and fine authority. Has the board increased its maximum fines to the $5,000 statutory limit? To the best of my recollection, our fine limit has always been $5,000, at least since I've been here. But the intent of cite and fine and its authority, and ELSA provides the use case for citation and the authorities that provide that. We're lucky in a sense that we can essentially write a citation for any violation of the PT Practice Act because of the way our language is written, which allows us to provide a greater level of discretion.
So what's the extent to which the board uses it?
you rephrase?
Well, I guess you are answering the question. I was just wondering if they wanted like regularity of it, or is that, I don't know,
That's why we provided the explanation of the range.
yeah.
Some boards are limited in the way their statutes and regulations are written, where they can only write certain citations for certain violations. And that other violations of their Practice Act, they actually don't have the authority to write a citation for, so they have to either choose not to act or to pursue discipline. And I think that question is really more gauged towards those boards that are kind of confined by their own practice language.
Okay,
And I have actually had EOs reach out to me as of late, asking for recommendations of language on how to stray from that kind of laundry list of things to a more generalized approach.
so I think I probably misunderstood the question. The question's just asking us to discuss the extent to which it's used, not asking how much do you use it.
Right.
Yeah, thank you.
How many informal conferences or disciplinary review committees, Administrative Procedure Act appeals of a citation or fine in the last 4 fiscal years? And you'll see that, again, 18, 19 being the high, but typically we do about 1 informal conference every other month. Obviously, sometimes that number can fluctuate, but an informal conference is essentially, after issuance of a citation, the respondent has asked for an informal conference with the board's executive officer to provide any kind of mitigation in the issue that we should consider in the issuance of their citation. In that informal conference, it's really their side, their opportunity to provide things to us. Once they've provided it, we'll go back and re-deliberate, if you will, to determine whether a change should be made or if it's appropriate, or if we should just let the citation stand.
Okay.
And you can see from the statistics in fiscal year 19-20, only 1 citation actually went on to a full administrative hearing. 44, here we've listed the 5 most common violations. Number 1 being that of criminal conviction, 2 practice issues, 3 the discipline that was imposed by another state, and California is essentially just echoing that state's ruling. 4 continuing competency violations, typically found in an audit. 5 other simple departures of the PT Practice Act. What is the average fine pre-appeal? The reason it's in X is we're still trying to collect that data as far as an average for time since last sunset anyway. Citations issued in the last 4 fiscal years have been issued with a fine ranging from $100 to $5,000. The final citation fine amount post-appeal averaged $779 over the last 4 fiscal years. And so the average fine pre-appeal is something that we're going to have to try and discern through reports, and it's going to require some hand calculation. Upon failure to pay, describe the board's use of franchise tax board intercepts to collect outstanding fines. In the event the board issues a citation and that citation is not paid within 180 days, the board can determine after a reasonable amount of time to report that as a loss to the franchise tax board for them to collect on our behalf. It's a limited tool in the sense that the licensee that the citation was issued from has to have had financial earnings in the state of California for us to garnish. If they left the state, which sometimes is the reason for not paying a citation, then the FTB intercept is ineffective. And right now we have 7 cases on file with a total of $9,770, which really is not a substantial amount considering the board's budget. Cost recovery and restitution. We just described our efforts to obtain cost recovery. Not much has changed since the last review. We do try to negotiate cost recovery as part of the settlement process. But costs are determined on a case-by-case basis, and discretion is applied, including considering the respondent's ability to pay, whether the costs were commensurate with the investigation and the outcome. All of those things ultimately combined lead to the final determination. How many and how much is ordered by the board for revocation, surrenders, and probationers? There's no specific amount attached to cost recovery for something like a revocation. It all does come from the prosecutorial and investigatory costs that were associated with that particular case. And again, the amount of cost recovery is sometimes reduced if the amount is paid within a certain period of time. We have, through settlement, offered a reduction of costs if said costs were paid within, say, 180 days to provide an incentive for that cost recovery.
Do you have an idea of how this is viewed by the audience reading it? This table? For instance, is that favorable or not necessarily?
You know, cost recovery isn't necessarily, I don't know that there is a favorable way to look at this, because it's such a wide spectrum. There are folks that think that, and when I say folks, I mean all parties involved, whether it be DAGs, ALJs, and licensees themselves, representative councils, and even the legislature, that cost recovery should be paid with revenues received for renewal fees and not on a case-by-case basis. And also, if a case goes to hearing and those costs are collected, the cost must be, pretty well established to be related to the case and supportive of the case before an ALJ will make a ruling to provide that cost recovery to us. And then, having said that, there are a few boards within the Department of Consumer Affairs that don't have cost recovery authority and are having almost the converse or opposite kind of situation, where because they haven't had cost recovery for so long, they're now going to get cost recovery to help bolster their finances. So it's kind of a mixed bag.
Yeah.
I mean, some people are in support of it conceptually. And then, of course, I think there's a contingent of the licensing population that doesn't think it's a good idea.
Just trying to get an idea of where we sit, but I guess just depends on what your color lens you're looking through, I guess.
So if you look at this most recent fiscal year, 51 cases that added up to $1.4 million. And here's the kind of thing to keep in mind. In that same period of time, we only collected $166,000, but that is probably $166,000 from the previous fiscal year.
Yeah.
And it might be on a payment or an installment program with a probationer. So there's a lot of factors involved. The way that it's captured here could be misconstrued if somebody's not paying attention.
That's a hard number to come by to calculate.
Well, it's impossible in the sense that while we've expended 1.4 fiscal year 2021, I can't tell you when I'm going to get it back or if. And I don't necessarily think that there's anyone who thinks that it's necessary that we do. But to the extent that we can get cost recovery from the bad actor, we should, just in fairness to the rest of the licensing population. What are the cases for which the board does not seek cost recovery? In those times where respondent is able to express extreme financial hardship, and as a point of negotiation, we will forgive cost recovery in settlement and negotiation. Describe the board's use of franchise task force intercepts to collect cost recovery. I think we only have one pending case with FTB for cost recovery, not citation recovery, but cost recovery. And again, it's about $9,000. Describe the board's efforts to obtain restitution for individual consumers, any formal or informal board restitution policy, and the types of restitution that the board attempts to collect. We don't have the authority to collect restitution. We have had, not within this last 4 fiscal years, but in the last sunset, we did have to report a Superior Court ruling that required the respondent to provide restitution directly to the board. And so we did collect that on a monthly basis. So, and that is it for enforcement.
All right, we've got about 40 minutes. We'll just try to get through as much as we can.
Mind taking another break?
Up to the members. Yes, it's needed.
10 minute?
10
Okay.
minutes, 4:30. I think we're doing good. Except for Okay, the time's 4:30. We're back on record from recess, picking up with section 6.
So for this particular section, it's mostly about outreach and public information. So just, wanted to thank April Beauchamps for a very kind of thorough and comprehensive addition to this particular part of the report. How does the board use the internet to keep the public informed of board activities? And as you can see, she kind of maps out everything a little bit step by step. All the different things that we provide, including agendas, meeting materials, meeting minutes, and that materials remain on the website for 4 years and then are stored internally for 75 as per the retention record. Does the board webcast its meetings? Yes, all our meetings are webcasted and then added to the PTBC's website and YouTube. We plan to utilize Webcast for all future board meetings. Webcasts stay on the website again for 4 years, but can also be found on YouTube until they're removed. The PTBC also started using Webex since the start of the pandemic, and this allows anyone to access the meeting remotely using a computer. Webex links are found on the meeting agenda or on the board's website. Does the board establish an annual meeting calendar and post it on the board's website? Yes, we do. In fact, we talk about that particular calendar at all the meetings up until that year, just to make sure that all the dates still work. And all of those calendar years are contained on the board's website for 4 years. Is the board's complaint disclosure policy consistent with DCA's? Yes, it is. The board's policy is consistent with DCA's recommended minimum standards. And the board is, we do post accusations and disciplinary actions consistent with DCA's website posting of accusations and disciplinary actions. And again, I think what they're just looking for there is consistency and making sure that we're actually doing what we're supposed to be doing. What information does the board provide to the public regarding its licensees? We provide information to the public in many ways. We do provide a progress note twice a year. And in each of those sections, all newly licensed PTAs and PTAs are listed, as well as any citations issued during that time. and reporting on any disciplinary actions that took place since the last newsletter as well. We also provide information to the public regarding its licensees through its homepage on the website. They can also use DCA search and pull people up by names, license numbers, locations, run reports specific to areas and demographics and so on. So
Is that right? Is that in here? Wait, the last part you just said?
on the homepage, there's a link to licensure verification through Breeze.
Yeah, is that in the body of this narrative?
It is
Okay,
middle of the paragraph.
thank you.
And then that system allows consumers, employers, and licensees to verify the status of PTs and PTAs as well as any other licensee issued by DCA or under
Perfect.
the umbrella of DCA. And that service is available 24 hours a day, 7 days a week online. The public may obtain a licensee's address of record and the physical therapy program completed by the licensee upon written request to the PTBC. What methods are used by the board to provide consumer outreach and education? Thanks to April, we have quite a bit. Consumer protection is paramount and therefore has recently shifted its limited resources to enhance its outreach program in an effort to meet its strategic plan. And we talk about social media platforms, Facebook, Twitter. We also utilize email blasts through listserv. Anyone can join an email blast by signing up on the board's website. The website includes a web page designed for consumers, a specific tab that they can click into for information specific to consuming physical therapy services. We also have progress notes in the newsletters that also cater to consumers as well as applicants and licensees. Public speaking engagements. At local colleges, but also through the Physical Therapy Association and even through FSBPT at times.
What about local, well, not local, larger like groups, like licensee groups, like hospital association or hospital organization?
We've only done one to this point.
Okay,
We did there's a particular saying, in service?
yes, it is an
Okay,
in-service.
so we did an in-service for UCLA, where we got close to 100 PTs and PTAs in the same auditorium, but that obviously was prior to COVID. It is something that, in a post-pandemic world, we want to return to doing in person, but now are researching just trying to do it through Webex and Zoom links as well. And then also our location of our board meetings. While we're mandated to travel to Northern and Southern California at least once per calendar year, whenever possible, we'd like to have those board meetings at an educational institution, either a PT or a PTA school, where we can get as much bang for our buck. Hopefully speak in front of a class of potential applicants and help them out with an understanding of the board, its existence, why, what we do, and how it affects them, and help them with their application process as well. And then there's just that small,
One moment, yes, Liz?
Staff was just saying, because we've been throwing the word workshop around and we have gone to that level as far as providing workshops, so we can just add that in this section?
certainly.
Do you think we can add it, that word somewhere in there?
Is that something that we did have called and we have been providing that?
Is it something that you can provide as an amendment by tomorrow?
Yes.
Okay, perfect. We'll present it to the board that way then, as a recommendation. And then the last sentence of that particular section, due to the global pandemic, meetings have also moved to virtual meetings utilizing the Webex component, with the exception of this meeting, of course.
And that's important because it has given stakeholders an added opportunity to attend a meeting versus traveling somewhere and attending in person.
Right, we do say that right before that sentence.
Perfect.
Anything more for section 6? Section 7 is very short.
So section 7's not talking about telehealth?
That is, it's very natural for you to assume that that's what it's for because of our board's, situation and COVID, but no. The prevalence of online practice and whether there are issues with unlicensed activity comes from things like psychology and behavioral sciences and folks holding themselves out to be life coaches or behavioral therapists of some kind providing online services, which essentially is the underground and unlicensed practice of those particular practice acts.
Okay. Thank you.
And
It
so,
is tricky though, isn't it?
yeah,
Are we confident that the committee is not going to ask about telehealth?
no, I think there's very much a potential for the committee to address or to bring up telehealth, absolutely. Not as it pertains to section 7 though. But
Okay.
I could see, it coming up in conversation, because I am aware of certain members of the committee who are interested in telehealth, not necessarily as it pertains to physical therapy, but just kind of in general, and how it's been affected by COVID. And I think they're looking at it from an advocacy perspective, that there may be room for a broader authority for telehealth as a result of the pandemic, and so just kind of advocating for its use. Anyone in Division 2 can utilize telehealth services and just fall within the parameters or the means of the regulations and statutes that are governed by. But,
And that statement, that last statement is something that I might look to add, that anybody who does practice telehealth is under the same regulations for provision of therapy services.
as far as section 7 question, or just somewhere within the report?
And to me, because the second question, this is 3 questions. Or the first is just discuss the prevalence of online practice. But how does the board regulate online practice?
Okay,
We
excellent.
regulate online practice the same way that we regulate
Right.
in-person practice.
But,
But I understand your aspect of, like, protecting against people who are unlicensed, because that's definitely a component of the first sentence. But then, the first question, how do we regulate online practice? And that's a piece of what telehealth is, in my mind, to follow Alicia's thought.
Yeah, we'll certainly craft that and add it for your review tomorrow.
Did this question exist before the notion of telemedicine?
Not before the notion of telemedicine, but well before the prevalence of telemedicine in PT as a result of the pandemic, right? So this question's been on the template since our last sunset, and that was 2016. And I believe it was on the template prior to that too, which was 12 and 13. And again, it's addressing a specific issue with a unrelated profession. But we'll craft a sentence that answers to question 2 of number 58. Okay, so section 8, workforce development and job creation. What actions has the board taken in terms of workforce development? Again, we don't have a mandate that speaks to workforce development, but we do continually monitor workforce needs through input from our licensees and employers. But until we have any kind of concrete current information on the actual size and distribution of the workforce, determining a need for the action by this particular board is difficult. If requested, the PTDC provides consultation to existing and developing educational programs in addition to participating in discussions related to workforce issues on a national level. And while we do not currently conduct studies to monitor national data, we do look to other organizations that do. One of the other things that's not stated here, but is probably going to come to fruition by the time we go to our sunset hearing, is that there is a new statutory authority that's going to be imposed and start in July of next year that does require us to voluntarily collect demographic information upon renewal. And so in the next sunset report, we'll be reporting that in this particular question. Describe any assessment the board has conducted on the impact of licensing delays. And other than the day-to-day efforts to streamline the process, we haven't conducted an assessment on the impact of licensing delays as they pertain to job creation.
Can we hold on there just for a second so
Sure.
I can think about that? Okay,
It's kind of a quirky question
yeah,
in a quirky section of the report. And it really is looking at the board's ability to, or the board's requirement, if there's any kind of statutory requirement to collect workforce data, and then what have you done with it? And an assessment in licensing delays as it pertains to job creation really isn't something that this board has ever involved itself in before.
no,
Some boards within the department are statutorily mandated to do it. So it's the reason for its existence. And it has a question in the template, though.
okay, I'm good with it. Thank you.
Okay. Describe the board's efforts to work with schools to inform potential licensees of the licensing requirements and licensing process. And here's another kudos to our outreach coordinator and communication coordinator. We provided presentations to 83% of the PT and PTA programs in California. These presentations are on laws and regulations that govern the practice and the application process for licensure. The board also attends the Physical Therapy Association's Student Conclave and annual conference every year to talk to potential and future licensees that attend as well. April has a comment.
Just to be consistent with section 6, we're gonna, if that's okay, change the word presentations to workshops.
How about and workshops?
And got it.
It's both, right?
It is.
Yes.
Yes.
Sometimes our presentations turn into workshops. Moving to 62, describe any barriers to licensure and or employment the board believes exists. The only thing that we've identified here is the TOEFL requirement. And while we have had an exception in statute for those that were educated in English-speaking countries, and we list them out, actually, I'll have to highlight that because I think that is content from the last time around that
Yeah.
we actually achieved.
That's what it looks like.
So we'll refresh that with the recent statutory exemptions that we received during sunset. Provide any workforce development data collected by the board, such as workforce shortages.
Can we go back to 62? Were we not going to include the barrier of mandating a level 1 CCIP CI for a supervised clinical practice?
We certainly could.
It is a barrier.
I think the question then becomes whether it's necessary or not,
Whether what's necessary.
that requirement. If it's, if it was sought as a mandate for consumer protection and in adhering to a specific standard and removing it, would lessen consumer protection in any way. So I agree that it's a barrier, but some barriers are more necessary than others. There may be other opportunities in this next legislative session to address that also. I know that we've been receiving a lot of inquiries from DCA through the Legislative Affairs unit about things like TOEFL and providing examinations in more languages than just English and translating documents and that kind of thing. So, like I said, there may be an opportunity to bring that conversation into a different piece of legislation.
Okay.
Is the MPTE offered in any other languages besides English?
No. Nor is the California law examination. Healthcare is kind of in this weird situation right now because there are opposing forces. There are those forces that think that English, being proficient in English is one of the keys to better practitioner and patient outcomes because you're all communicating in the same language and you're all proficient in doing that. So much so that we've actually required a good portion of Division II licensees to do TOEFL if they're trained outside of the United States. But we have this kind of pendulum that's swinging back in the other direction also, almost in opposition of that idea. And so that is something that we're going to have consider in the future. Still on 62 or 63?
And we can move on.
Provide any workforce development data collected by the board, such as workforce shortages. Because of the way our licensees are listed, we don't have, and because we don't have the statutory authority to collect that data, we do base some of our decisions in our deliberations on Bureau of Labor Statistics, and know that the profession has continued to grow over the last couple of years and is projected to do so all the way out to 2030. Our licensees aren't mandated to report to us where they work, just their address of record and their residence address. And so it would require a statutory change for us to start collecting workforce data. Successful training programs. Currently, there are 18 credited PT, doctorate level PT programs in the state and 19 PTA programs. The average pass rate for a U.S. graduate taking the national examinations, 83% for PT and 73% for PTA. And then California's MPT pass rates are consistent with that of the national average with FSBPT. On to current issues.
Yes.
Okay. What is the status of the board's implementation of the uniform standards for substance abusing licensees? The PTPC implemented the uniform standards in April of 2013 under Section 16 CCR 1399.15, known as the 5th edition, Guidelines for Issuing Citations and Imposing Discipline, and is currently promulgating amendments to CCR 1399.15, and will be known as the 6th edition. What is the status of the board's implementation of the Consumer Protection Enforcement Initiative? Again, the PTBC implemented CPEI in August of 2012 under CCR 1399.24. Describe how the board is participating in the development of Breeze and any other secondary IT issues affecting the board. Is the board utilizing Breeze? What release was the board in, and what is the status of the board's change requests? And yes, we do use Breeze. We were in Release 2, which was implemented in 2016. What is the status of the board's change requests? We do not have any significant requests pending at the time. If the board is not utilizing Breeze, again, so that's a question that is non-applicable.
Okay. I think we should stop at section 10 because we're right up against 5 o'clock.
Okay.
So we'll resume with section 10 tomorrow. And today's agenda, actually, we have closed session that we'll be moving into, and we will not be opening back into open session today. We'll resume tomorrow. But we do have one last opportunity for agenda item number 8, which is public comments that are not on the agenda. So are there any public comments not on the agenda? And I hear none. And so I think we're okay to go into recess.
We are.
All right, thank you everyone for your hard work today.